Welcome to Looking at Legal Stuff. Today we have day 3 of a 3-day jury trial in the divorce of a couple where the older husband has petitioned the court for divorce after a DV incident that led to a 12-month TPO against the younger husband and him being jailed on charges of stalking. The younger husband, who didn't have a job during their 8-year marriage, wants his ex to pay him alimony for the next few years, despite the fact that he is currently on house arrest for the previously mentioned DV incident. In addition to the fight over alimony, they both want to keep the dog. Will the jury believe any of the wild allegations this toxic couple makes against each other? Let's find out. This case will be split across 3 videos, one for each day of the trial. But not to worry, it'll be easy to find all 3 videos. I'll link them all for you in the description box below.
All right. Good afternoon, Ms. Yarber, Mr. Piner, Mr. Polanco, Mr. Terry. Good to see everyone. We need to have a charge conference before we bring the jurors in and start with closings. Thank you. I have put up on the screen the charge that I distributed a few days ago now, I think, at least early yesterday at the latest. The way I'm going to go through it is to jump to areas where I've got a question or concern. If I pass over an area where you've got a question or concern, just bring me back to it and we'll talk about it. It is almost all pattern charges. I modify the patterns, 1, to fit the facts, but 2, I'm an advocate of plain language. And so the pattern may have been modified so that it reads in English rather than legalese, but the legal points are intended to still be there. I am open to rewording if either side thinks it's necessary. So first, if we get to grounds of divorce, which is on the screen now, the paragraph labeled divorce, we actually covered this yesterday. And I think, Mr. Polanco, you agreed. I just didn't want to delete it because it would mess with the pagination you had before. But I'll be telling the jurors that Mr. Piner is seeking divorce on the basis of irretrievably broken, and Mr. Terry is on the basis of cruel treatment and not the other 2 grounds. You agree?
Yes.
Excellent. The irretrievably broken language has 2 paragraphs. I don't believe we need the second one. I think the first one is sufficient. Ms. Yarber, are you okay with how I have modified irretrievably broken?
Yes, Judge.
Cruel treatment. I think we didn't need that middle sentence. I think that the point is made partly through testimony we've already had, but the language that I have there is sufficient. Mr. Polanco, are you all right with the language? Yes?
Yes.
Great. I don't think we have any evidence of appreciation in value of non-marital property. So that was a pattern someone asked for, Ms. Niles, when she was preparing this. We hadn't heard all the evidence. I think we should strike that. Ms. Yarber, are you all right with that?
I agree, Judge.
Mr. Polanco?
I agree.
I don't think we need to get into partitioning because no one is saying I should get 1/3 of the apartment or half of Sozo or something like that. Do you agree, Ms. Yarber?
I agree.
Mr. Polanco? I haven't highlighted this, but now that Mr. Terry has testified about alimony, well, but I guess the jury could think of it that way. I was going to say we could strike alimony in kind. It's not listed in the verdict form. It's not really what anyone has ever talked about. Mr. Terry has been pretty clear that it would be a sum of money on a periodic basis for a few years so he could get back on his feet or move forward. He's phrased it the way he did. And so I think lump sum is appropriate and clearly periodic alimony, and both those are in the verdict form. I think we can keep things a little more focused for the jury. If we don't talk about alimony in kind, they'll be dealing with the property division anyway in a separate part of the verdict. Do you have any objection, Ms. Yarber, to removing what is right now subparagraph B, what I've turned gray on the screen?
No, I think it should be removed.
Okay, Mr. Polanco?
Agree.
All right. I will remove that and redo the paragraphs there. And that was it for me. Ms. Yarber, do you have anything you think should be added to or subtracted from the proposed charge beyond what we just discussed?
No, Judge.
Mr. Polanco?
No, Judge.
Well, you all were awfully agreeable when it came to jury charge. That's usually when the lawyers are tired and ready to move on. But I think it was a jury charge that'll work. So you know the way I handle jury charge. When you're done with your closings, I will read this to them. You'll have a final version. I'll get you both a hard copy of the final version. It'll have the changes we just talked about. I will read it to them. It will also be on the screen so they can see it one paragraph at a time, and they get a hard copy. So what I read to them will be distributed, one copy to the jury for their deliberations. Ms. Yarber, do you have anything else we need to cover before the jurors come out?
No, Judge.
Mr. Polanco?
I may. So the exhibits, are they in order and organized or flying all over the place?
Closer to organized than flying all over the place. Your exhibits are still up on the witness stand, so you may want to come grab them. And then we should do this before we bring the jury in, so they're not stuck waiting for exhibits. I'm going to go over the list that I've got of what was admitted and what wasn't. And Ms. Yarber, your exhibits exist in paper format somewhere, or how are we getting yours to the jury?
I have a paper copy.
Okay. I'm going to start with yours. I'm going to share with you what I think was admitted, and then you and Mr. Polanco can let me know. And then we'll do the same with Mr. Polanco. I know he's got hard copies because I think they were all right there. So starting with petitioner, 1, 2, 3, 5, 8, and 11 through 16.
Yes.
I have as that's it. So no 9, no 10, but the numbers I mentioned, I guess no 4. Those were all that I have as admitted. Do you agree with that, Ms. Yarber?
Same list, Judge, yes.
Okay, Mr. Polanco?
Yes. Remind me, 16, that was yesterday.
That's your client's financial DERFA.
Oh, that's right.
I never heard it called a DERFA, but Mr. Piner said that, so I'm going to say that. On respondent side, 1 through 5, 9, 10 through 16, 19, 20, and 21 is what I have. Do you have anything different, Mr. Polanco?
I am trying to remember, I was not doing a great job on keeping track of my exhibits on that, but yes, the numbers sound correct. I remember let me compare it against one list that I have here.
Okay.
Okay, D6 is definitely not in.
Right, 6 and 7 are not in. Right,
8 is photos of dog. I think that was.
that's in. Yep.
9 is in.
And 10
10
through
16.
10 through 16.
Skip 17, 18, correct.
Right.
That's not in.
19 is in,
Yep, that's correct.
20 and 21. So if you've got yours, Ms. Yarber has hers. I'll add to that the jury charge and the verdict form. Ms. Yarber, did you have a chance to look at the verdict form?
I did, I had 3 words I wanted to add.
Okay, let me open it here. And Mr. Polanco, did you get a chance to see the verdict form?
So that was my proposed, yes.
Well, it was. I modified it. I removed some things because they aren't at issue here. So it will look like yours, but there are some changes. Yours, as originally drafted, had the jury deciding should there be a divorce. I make that clear. They're not deciding that. There will be a divorce. The question is, what are the grounds and what do we do with the property? And alimony. So, Ms. Yarber, I'll start with you. You had 3 magic words.
It is in section 1. It's not on the screen, but I'm.
Oh, let me put it on the screen. Sorry, I still got the jury charge up there. Let's stop sharing that one. And All right.
Okay, 3 magic words, up under section 1, the second prong that says cruel treatment by petitioner Piner. I would like for it to read cruel treatment by petitioner Piner towards respondent Terry. I'll make that extremely clear. That's my only request, Judge.
Okay. I think that's a factually correct, more complete sentence. You were worried they might think about sozo or something else. Okay.
Correct, Judge.
Any issue with me adding those 3 words, Mr. Polanco?
No, sir.
Okay, they're in. Do you want a minute to look more at the verdict form, or are you good with it?
Satisfied, Your Honor.
Okay, then I'll reprint that with those 3 words in it. We'll have a verdict form. We've got the jury charge. Mr. Polanco, anything, thank you for flagging let's make sure we've got we're talking about the same exhibits. I think we do. Anything else before the jurors come in?
Nothing else, but just a minor point on the exhibits. I have these paper clips that I absolutely highly recommend and highly encourage anybody who works with a lot of paper to use these.
Yeah.
But I think it might be better to staple them. Does the court agree? In other words, so the paper's not flying all over the place, or?
And I kind of just put mine cat corners on one another like that, so.
Okay, are yours stapled or not stapled?
They came right out of the binder.
Okay, it probably makes sense for us to staple so that, for example, your exhibit 1, Ms. Yarber, is probably a few pages long because you were scrolling through photos.
Yes, but the
And I have-
copy that I have, I actually gave to counsel. I don't know if he still has it or not.
Yes, I have it.
Oh,
The photos?
yeah.
Yeah, sure.
I would like to have it then.
Is that your exhibits 1 and 2 and 3 were all photos? Do you not have those anymore? You have them if he has them?
Yes.
Okay, so hopefully you can get those
So I have
back.
2 copies of 2, but.
Yeah.
Thank you. Problem solved, Judge.
Excellent. But some of the exhibits may be too thick for us to staple.
Oh, yeah. I put those in that thicker clip.
Right, so it may be that we just stick with your,
I have these 2. Thank you.
Oh, you did?
I needed this one. Thank you.
okay. So let's leave them as is right now. And I'll think about it. If we need them stapled, I'll get a stapler to you guys when we're done with closings. I just don't want people stapling during the other person's closing. If anyone's going to use a PowerPoint or want something on the screen, you know how to share screen. You've been doing that. I think we're ready to go.
All right, the jury. You're the president of the county court.
Thank you, Deputy Gordon. Good afternoon, everyone.
Hello.
Welcome back. We are ready for closing arguments or summations. You all can be seated in the matter of Piner versus Terry. Talked about it with the lawyers. Mr. Polanco is going to go first. He's going to share with you the facts as he understands them to be. He may talk to you about the law, and you're free to listen to him about the law. But ultimately, I'll be telling you what the law is that you must apply to this case. And I'll do that once the closings are done. I mentioned this in my opening remarks. It bears repeating now. You should feel free to be persuaded by what these lawyers tell you, but keep in mind, what they say is not evidence. The evidence is closed. There's no new evidence. What we're doing now is connecting dots and making conclusions from the evidence you've already heard. Witness testimony and all the paper evidence. And every document that was admitted, you will have with you during your deliberations. All of petitioners' exhibits as well as all of respondents. So the lawyers will seek to be persuasive, be persuaded. That's okay. It's just not evidence. All right? Mr. Polanco, when you're ready.
Thank you, Your Honor. Okay. Okay, so good afternoon, everybody. Thank you for being so patient throughout these 3 days and listening to Secretary's story. Ladies and gentlemen of the jury, as jurors, you've been asked to decide on three key issues. Number one, what is the ground, meaning what is the reason for the divorce? Mr. Piner, on the one hand, seeks a divorce based on an irretrievably broken marriage. Christopher Terry has counterclaimed and sought a divorce based on what's called cruel treatment. So that's the first question that you have been asked as jurors to decide. Second, how is the marital estate to be equitably divided? The marital estate includes all of the things that we've been hearing about over this past couple of days. And lastly, the third issue that you've been asked to decide upon is, should Mr. Terry receive alimony from Mr. Piner? So those are the three issues that you've been asked to decide. Now, the judge, after closing arguments, is going to give you what's called jury instructions. Jury instructions are statements of the law that will guide you as jurors to apply the law to the facts of the case. And he will define a variety of terms. So for example, one of them is the burden of proof. What does that mean in a civil case? The judge will state, for example, that each side has the burden of proving what he seeks based on the testimony and the exhibits. He will define that evidence can be circumstantial or direct, and that evidence can include the testimony of the parties. He will define that you, as the triers of fact, as the investigators of the case, if you will, are the ones that get to decide who is believable, who is credible in this case. Who do I believe about their version of what happened on X, Y, or Z day? You can consider based on your own experience, based on the observation of the party's demeanor, et cetera, and the testimony that you heard, you can decide, well, what is the motive for this person saying what he's saying, right? You can look into the bias or the animus of that person. That can include the feelings that the person has towards the other party, whether it's positive or negative, whatever the case may be. As I said, there are two grounds that are being alleged in either direction. On the one hand, irretrievably broken. On the second, the cruel treatment. And the judge will define what those terms are. So that addresses the grounds, the first issue. The second issue, of course, is the equitable distribution of the marital estate. So for that, the judge will instruct you, for example, that you first have to define what encompasses, what's included in the marital estate and what's non-marital estate. The general rule, and I'm stepping outside of the jury instructions here for a bit, is that, of course, and everybody sort of heard this, is that property acquired prior to a marriage is usually separate property, right? Non-marital property. But, and this actually I'll talk about this in a minute when I start talking about the Nissan, there are actions that the parties can take, that the person that had the separate non-marital property may take, or they may take actions together, which may convert non-marital property into marital property, because of certain actions that were taken. So the judge will also give that instruction regarding non-marital property. And he will discuss the many factors that you will consider as you consider equitable distribution of the marital estate, whatever is in the marital estate. Whatever property was acquired during the marriage, as a general rule, was considered marital property. And that's the second issue to be decided. The third issue, as I mentioned, is the alimony. An alimony, the judge will define as an award for the support of the other while living apart. It is not a matter of right. So you may, but are not required to consider all the factors that the judge is going to give you in determining whether alimony is appropriate in this case. Okay, and then he will discuss the two types, of alimony, whether it's lump sum or cash form. And so those are the three issues being asked that we are asking the jury to consider. Now, after being very patient, we submit that Christopher Terry has met his burden of proving that this divorce should be granted based on cruel treatment. Why? because both the beginning of the relationship and the end of the relationship in 2010 and 2025 respectively lack a proper justification. And I'll explain what I mean by that now. In my view, there is no reasonable explanation for the events of 2010. There is no reasonable explanation for the events of 2025. When seeking to end his divorce from a person that he had been married to for 8 years, the petitioner who is seeking the divorce did not ask Mr. Terry for a divorce. He didn't ask him orally. He certainly didn't do it in writing, not even via text message. Instead, a year ago, Mr. Piner came to this courthouse, Fulton County Annex, maybe somewhere else, sure, and obtained an ex parte TPO. It was served on Mr. Terry the same day at their home in Alpharetta, where they had lived since 2016. The petition, which automatically grants a 30-day TPO on an ex parte basis, alleged numerous acts of family violence. Specifically, Mr. Piner listed these. Number 1, 2014, Mr. Terry slapped Mr. Piner in public in Gwinnett in front of a community health center. 2015, Mr. Terry told Mr. Piner. Those were the pictures that were submitted in P1. 2017, Mr. Terry threw a plate. Over the years, Mr. Terry punched, this is number 4. Mr. Terry punched holes in the wall, whether by punching or throwing things. Number 5, Mr. Terry regularly empties trash bags on his husband's head. July 2025, Mr. Terry threatened Mr. Piner's life multiple times. Police were never called for these death threats. Number 7, Mr. Terry put his hand over Mr. Piner's nose, obstructing breathing, usually when trying to call police. Number 8, July 6th, Mr. Terry was breaking things in the kitchen. Mr. Piner tried to call the police to prevent the call. Mr. Terry broke the phone. July 12th, Mr. Piner tried to call the police again. We do not know why. Mr. Terry slammed Mr. Piner's phone to the ground and scratched his hand. The same day, this is all included in what's been introduced as the TPO, which is my exhibit 21. And I believe it was introduced by the petitioner as well as another exhibit. On the same day, meaning July 12th, Mr. Piner was trying to take a nap. Mr. Terry was screaming and wouldn't let him sleep. This affects the hearing. Mr. Piner called police. This call was evidently not interrupted because police arrived and took Mr. Terry to the hospital. So I submit that the allegations, even when taken at face value, are internally inconsistent. You cannot be screaming at somebody when you're trying to take a nap and you call police so that you can go to sleep and allow you to take the nap. And at the same time, you're trying to call police on the same day and the phone is broken. So either the phone is broken and the call is obstructed or the call goes through. Even when taken at face value, Mr. Piner's allegations are internally inconsistent. So far we have 10. Those we know from the TPO from July. But under oath, in this very courtroom, he alleged other acts of family violence. Specifically, he added 5. He said that Mr. Terry used drugs, that he was regularly unfaithful and adulterous, that he did not get a job or even try, sprayed a bottle of Febreze, and threw the dog at Mr. Piner. Now, in fairness to everyone, because I think we've all learned a lot together, at the outset, I do admit that the parties share some characteristics in common. However, I submit that that quality expresses itself in two very different ways. Mr. Terry's naivete is profound. It's palpable. You can just feel it. But it's also very good-natured. Mr. Terry weighs maybe 130 pounds and is fundamentally a very, very caring, loving, and sweet person. He is not a violent person. He's not the man that is being described to you. By contrast, the naivete from which Mr. Piner exhibits is, I don't know if there's another, it's there's something mysterious about it. And you're being asked to judge his allegations based on that credibility. Okay. 7 days after Mr. Terry was served with the TPO on July 15th and he left, he had to sleep in his car, which was the Nissan 370 that he had inherited from his mother. He slept in that car for a week, and then when the car was stolen, he was left without a car, so he had nowhere to sleep. He was now functionally, completely, fully homeless. And so, so Mr. Pine received a text message at 1 p.m. which said, car stolen, help, and it had an address in downtown Atlanta. At 5 p.m., Mr. Terry walks into the house in Alpharetta, but Mr. Pine is accompanied by two people. They stop his entrance and he leaves without incident. He's escorted out. A week later, July 31st, he gets arrested for violating the TPO, a charge that is called aggravated stalking. Now, Mr. Terry did not respond to the single text message, and it was a single text message asking for the help because the car, the Nissan, which had actually been placed under his name after the car had been sold back and repurchased. Now the Nissan had become marital property because it was sold to the dealership and then purchased back during the marriage. This is a car that is legally under the petitioner's name. So you would think that he would at least show some concern about what happened to him. After all, his name is on a loan that is related to that Nissan. But he doesn't. He doesn't show an ounce of care or empathy for the car because presumably he has achieved what he wanted, which is to get the spouse out of the picture. Now, when Mr. Terry is arrested on July 31st, this causes Mr. Terry to also miss the hearing that you get in Fulton County when somebody applies for an ex parte. You get a hearing where you get to come to court and say that's not true, that didn't happen, that the 12-month order should not issue. He never got that opportunity because he had been arrested, right? And so he spent 8 months in jail, getting out eventually on bond, wearing an ankle monitor that now prevents him from stepping outside of the apartment in which he stays. He stays borough. And so therefore he's physically unable to get a job, even if he wanted to. So Mr. Terry has been placed in quite a very, very, very narrow space, right? He doesn't have room to maneuver. And he was served at the jail. So he learned about the divorce from the jail while he's sitting there for a couple of months, a month. He gets a sheriff to deliver these papers, and it's titled "Complaint for Divorce." And he reads it and he says, "This is my husband serving me these papers in the jail. He's saying that our marriage is irretrievably broken, that everybody gets to keep their stuff and kind of go their own way. I keep my Toyota Prius, you keep the Nissan. Although of course the Nissan has been repossessed and stolen. And I keep the dog." So at that point, Mr. Terry says, well, I really don't know what to do at this point. I'm gonna have to get some help. And so he asks for help and he gets it. And that's sort of where I came in. Going back to the statements about the acts of crime and violence, excuse me. Not only do I submit that the statements are internally inconsistent, but I submit further that you should take them with a grain of salt for another reason still. Okay. When asked to describe very early on, when asked to describe whether Mr. Piner had anything good to say about these past 8 years or even longer, of dating time, he described the relationship to what I found to be a somewhat peculiar way. He said, we laughed and played video games together. It was a situationship in my mind. We were friends and roommates. I ended up living in his grandma's in separate rooms. The marriage was one of convenience, orchestrated so that Mr. Terry would not lose insurance. I wish him the best. Now, I submit that Mr. Piner is not credible. Full stop. That ends here today. Now, Mr. Piner, like Mr. Terry, took an oath to tell the truth, the whole truth, and nothing but the truth. It's an old concept that goes back to the 1200s. And in the old days, and this is somewhat interesting, I think, the reason we're asked to raise our right hand when we swear an oath is because the left hand was already taken. Left hand usually was tied to either a stone in the Roman times, the Jupiter stone in the Capitoline Hill, or in the Jewish tradition, it was usually, it was also a rock. Other religions have different things, like for example, garlic or onion. The point is that the stone represented the connection with the divine. It represents a connection with like another spiritual world, in which you're basically saying that I am swearing that that whatever I'm going to say is true, and God cast me down if it isn't. Now, historically, humans were very religious. The people of the Middle Ages, for example, when they swore to tell the truth, they had an inconsumable fear if they didn't tell the truth, because that meant eternal separation from heaven. In my opinion, Mr. Piner was not entirely truthful about those 8 years of marriage. He also wasn't entirely truthful about the 15 of relationship. Now, just as much as the beginning and the end, the two sort of bookmarks at either end of this story were cruel. In my opinion, I submit everything in the middle was also cruel. And what do I mean by that? See, I'm not going to rely too much on exhibits, but I'll just try to see if I can pull one up. Okay. In Respondents Exhibit 4, and let me see if I can zoom. This is dated October 2019, right? So this is 2 months before the marriage itself. There is a disagreement because Mr. Terry has gone elsewhere. He's gone to State Bridge Road. And this causes some sort of series of chain reactions that turns into this string of abuse. We're 100% going to break up. Mind you, they're not married yet. I pray to God that he convinces you to leave me. I would give my soul over to S willingly to live eternally forever in hell. Please, S, take my soul, etc., etc. Please leave my life. I will be a willing servant of S. This is 2 months before the marriage. Now, towards the end, and I believe it was Exhibit 20, we see the same pattern. Of course, this is a month before the TPO, before a month before the TPO issues. There's these talks about let me see if I can zoom in a little bit closer. All right. Can you read that or? Okay, no matter how you word things, I'm not able to further support sin in my life. I hope you have a fantastic day. You're not loving me the way I want because I want my identity in Christ and not sin. A man cannot love another man the way a man can love a woman. Do you need moving boxes? So, this is, of course, a month before. This is June 19th. A month before the TPO. Once again, when seeking divorce, the petitioner didn't ask Mr. Terry for a divorce. Can we just tell you, please? Talk about it, look at it. He just simply called the law. And the law showed up. So in my view, the only image that emerges inevitably is one of either cruel indifference or just innate cruelty. Given who both Mr. Piner and Mr. Terry are. Issue number 2, the equitable division of the marital estate. Now, at the outset, it's helpful to start with what doesn't belong there. So the personal belongings in the extra space storage in Alpharetta are not marital property, we said that. So that case, and nobody disputes that, we agree that Mr. Terry should get his personal belongings back, some of which were inherited from his mother in 2018. Now the marital estate. Is this a large marital estate? No. We're talking about a very limited number of things. We're talking about the Nissan. The Nissan 370 is a good example to start with because it was inherited by Mr. Terry in 2018 because his mother died before they get married. Then it's sold to the dealership, bought back, and therefore, because the commercial activity takes place during the marriage, it should be considered marital property. The Nissan is also in Ohio, repossessed. So maybe out of reach. The Toyota Prius was bought in 2019. It's used by Mr. Piner to drive to and fro work. I'm not saying that he needs to split a car in half, but it is valued at $9,000. The dog. It was purchased in 2019. You've heard testimony from either party as to who the dog truly belongs to. That issue is in your hands. Income and retirement accounts. Now, Mr. Piner generally earns approximately $130 per year at his job at Virtual Marketing LLC. as a contractor for Pfizer. That turns out to be, according to his petitioner's exhibit number 15, which is the domestic relations financial affidavit. It's $11,500 per month. Out of that, $3,000 gets taken off for taxes, leaving $11,500. Out of that, leaving $8,500 net. He claims expenses of $6,000 per month, which does not include another $1,000 that he's paying to settle certain debts that he has with creditors, okay? So all in all, $8,500 minus $7,000 leaves $1,500 left over. Mr. Terry is asking for $1,500 per month for 2 years to get himself on his feet. I think that's appropriate. He thinks it's appropriate. Mr. Terry has never worked for anybody but his husband since 2010. He didn't get paid as an employee between 2010 and 2018. As a husband, I suppose we don't have to get paid under the labor laws, but that's the only job that Mr. Terry has ever had. That's the only experience, the only reference that he can actually put on a job application. Mr. Terry deserves alimony in this case. That's the third issue for you to decide. We hope that you agree with Mr. Terry's contention.
Thank you, Mr. Polanco. Ms. Yarber, when you're ready. Thank you.
Good afternoon, guys. Thank you so much for being here. Third day, we're about to be done. So I have several notes here that I've been taking. I know that y'all have been also keeping up with myself and counsel on what we're doing during the trial. I have several notes. I'm gonna go through them in a concise manner so that y'all can know exactly what we're asking for, what our arguments are, okay? So we have spent 3 days here. 3 days of testimony, 3 days of exhibits, 3 days of listening to very different stories about the same 8-year marriage. And now it's you all's turn. So let me be clear about what we're asking you to do. We're asking you to, 1, deny Mr. Terry's request for alimony. 2, keep and let my client keep any debts that are in his own name. That's it. Let Mr. Terry pay for whatever is in his own name. 3, award my client the dog. So soon. 4, award my client his Toyota Prius. Is it Prius or Toyota? That's neither here nor there. Award my client the Prius. The opposing party does not need a car to go anywhere. He doesn't have a job and he's on house arrest. So keep that in mind when you're thinking about who to award the vehicle to. 5, we want the respondent, Mr. Terry, to pick up his stuff from storage by the end of this month. Okay, now here's why you, the jury, should grant what we want. You've been instructed that you must make your decision based on the preponderance of the evidence. So what that means is that you decide the case based on what is more likely than not. So the greater weight of the evidence, the same evidence that we've been showing you all on the screen, and the same evidence you're going to have when you go back to your deliberation room. That is the standard, and that is what the law requires. Now, what is the evidence? The evidence is the testimony you heard from the witness. The evidence is exhibits that were admitted. The photographs, the text messages, the financial affidavits, the protective order, the criminal pending charges, the receipts for the biohazard cleaning, all of that. The evidence is not what the attorneys say. If you want to take what I say, the evidence is not what the attorneys say. So the evidence is not even what I'm saying to you right now. The evidence is what you saw and heard in this courtroom via the exhibits and the party's testimony. So I'm asking you to look at all of that evidence and make a decision based on what you saw. So let me start with the most important thing. The most important thing you need to understand about this case is abusive and manipulative relationships seldom make sense because the victim often does whatever they can to limit the abuser's anger. That is my take on what we saw. So my client, David Piner, is a victim, period. He's a victim of physical abuse. He's a victim of emotional abuse. He's a victim of financial abuse. He is a victim of manipulation, and the evidence of that abuse is overwhelming from what I saw. So you heard David testify about what the respondent did to him. You heard about the destruction of his CPAP machine, the machine that he needs to breathe at night. The respondent destroyed it. Mr. Terry destroyed it. Why? To control him, to hurt him, to show him who was in charge in that relationship. You heard about the slap in the face, the strangulation, the Febreze that was sprayed in his eyes. Can you imagine that? Someone spraying a chemical cleaner into your eyes. That is cruelty and that is torture, and that is what my client had to deal with from his husband, quote unquote. You heard about the broken work laptop, and you also saw pictures of it that we provided on the screen showing that his work laptop screen was busted because the opposing party did that. Now, why would my client do anything to his work laptop if that's the only means of him having any income? It doesn't make any sense. The respondent broke my client's laptop. He sabotaged his ability to work. He sabotaged his livelihood. He sabotaged his income. And then he has the audacity to ask David to keep financially supporting him. You heard about the holes that the respondent punched in the wall, and you also saw the holes. You saw my client's bruised ribs from being hit with a water bottle. There was constant physical intimidation, the constant fear that my client suffered at the hands of Mr. Terry. Now, Mr. Terry also, you heard evidence, prevented my client from sleeping through the night by yelling, making noise, and intentionally keeping him up. All of this points to manipulation. And the emotional abuse, let's go to that. So my client, David, he would purchase clothes for himself, simple, basic clothing. And the respondent would take those clothes, return them to the store to get the cash, and then spend the cash on himself. That is not a partner, that's a parasite. My client even said that the opposing party would pee around the house just like the dog did. What was the dog's name? Sozu, just like Sozu. So we basically had two Sozus in the house. Got it. The respondent would go nonverbal, refusing to speak to David until David agreed to move him into a new apartment. What's up with that? He used silence as a weapon. He used emotional withdrawal as a form of control. He manipulated David into doing what he wanted, period. And here's the thing that should make every single one of you angry. When David testified about the respondent, Mr. Terry, breaking his CPAP machine, Mr. Terry was sitting right there over next to me at this table in this courtroom, and he was smiling and giggling. While all of you all had to sit here for this 3-day trial that he requested, he's over there smiling and giggling. He does not care about what he did to David. He has no remorse. He has no shame. He sat there and laughed at the testimony about his own abuse, and that tells you everything you need to know about his character. And this is not new. So this has been going on for years. In 2014, the opposing party, Mr. Terry, was arrested for slapping David in public. That was before they were even married. He has been abusive for over a decade. It's 2026. So he is currently on house arrest for what he did to David. He has a nice little bracelet on his ankle. It is not like the bracelet I have on my ankle. He has an active protective order against him. A judge found that my client, David, needed to be protected from this man. That is how you get something like that granted for 12 months. You don't just get it willy-nilly. He has pending charges. Mr. Terry has pending charges for aggravated stalking against my client. He is a criminal, and he is a danger, and he wants you, the jury, to award him money. And he admitted it. So he admitted on the stand verbatim. He said that he goes through big emotions, quote unquote. That's how he describes it, big emotions. That's his excuse. So that is his justification, and that is the minimization. It is big emotions cause him to strangle his husband, spray chemicals in his husband's eyes, break his husband's CPAP machine. Big emotions cause him to punch holes in the wall that y'all saw. But big emotions do not give anyone the right to abuse another human being. So big emotions do not make you a victim, and they certainly do not entitle you to alimony, okay? Now, the opposing party wants this divorce to be granted on cruel treatment towards him, which is funny. He wants to stand here and claim he's a victim. He wants you to believe that David was cruel to him. Let me tell you why that does not even matter. Let me tell you why this has been a colossal waste of your time. So in Georgia, the practical difference between a divorce being granted as cruelty or irreconcilable difference is extremely minimal because the courts almost exclusively grant no-fault divorces. So while cruel treatment is a recognized fault ground, proving that it kind of requires airing out details in court, sort of like what you all saw, the irreconcilable difference ground or irretrievably broken ground for divorce is faster, cheaper, and yields the same result, which is getting them divorced. So we're here going back and forth about nothing that matters, mind you. Whether it's up under cruel treatment or irreconcilable difference, it doesn't matter. So we've been here for 3 days, 3 days of your lives, 3 days of testimony, 3 days of exhibits for what? To argue about cruel treatment when the result is exactly the same regardless. Got it. The marriage is over. Everyone agrees the marriage is over. The divorce will be granted no matter what. So the only question is whether you're going to make David pay a man who abused him. So why are we here? Why did the opposing party request a jury trial? Okay, let me tell you why. The opposing party is a performer. That's the reason he requested a jury. He thought to himself, let me see how many people I can fool with my performance. I won't be able to fool the judge because the judge judges every day. His job is to judge, but a jury of my peers, I can fool them. And he performed. He performed for you. You all saw it yesterday. I saw it too. He was being asked questions, hard questions, tough questions about what he did to David, my client. And he's like, oh my gosh, I love David so much. I would never hurt him. He's my snuggle bug, etc. Meanwhile, he has on an ankle monitor for what he did to my client. That is a fact. So aside from his Oscar-worthy performance, the evidence showed the truth. The protective order, the house arrest, the pending criminal charges, the pending criminal conviction, the text messages where David was begging him to stop spending his money, the photos of the home in a state of biohazard by a man who also called himself a house husband. It's neither here nor there. He's a performer. He performed for you for 3 days, and bravo to him for having y'all here for 3 days. He got exactly what he wanted. He got a stage, he got an audience, he got 3 days of your attention, but do not let the performance fool you. Don't let the act determine your verdict, okay? Look at the evidence, look at the facts, look at the truth. There have been a lot of red herrings all through this 3 days. I'm about to point them all out to you. Let me actually tell you about everything in this trial that did not matter at all to what you all have to decide. Number one, the party's gamer profile history didn't matter. My client's ex-girlfriend doesn't matter. Anything that happened before December of 2018 when they got married doesn't matter. Whether they got married at an annex or their living room and the date that it happened in December, that went on for about 30 to 45 minutes. That doesn't matter. Whether they, any gay conversion therapy conversation doesn't matter. Anything pertaining to God or Satan doesn't matter. The respondent being served with the divorce papers in jail doesn't matter. And counsel just said in his closing that my client did not ask his client for a divorce. That's not even a requirement. So it's just more of him spending time during this hearing on things that do not matter. You don't have to ask somebody for a divorce. If you want a divorce, just go file it. It's not a requirement. And honestly, a whole bunch of other stuff the opposing counsel and party were spending hours on. Hours of your time, hours of my client's time, hours of the court's time on things that do not matter. Hours of my time. Counsel also misrepresented just now in his closing argument the TPO ex parte hearing. So counsel stated just now in his closing argument that my client filed an ex parte protective order and then had him arrested so that Mr. Terry could not attend the ex parte hearing. Did y'all hear that? Counsel does not know what ex parte means. Ex parte, a Latin phrase, literally means for one party. So a legal proceeding that takes place for one party without the knowledge or notification of the other side. So he's like, oh, he filed an ex parte, my client wasn't able to go. It's an ex parte, he wouldn't be able to go. It's for one party. That's literally how it works. So none of that changes the facts. None of that changes the views. None of that changes the fact that the opposing party is a 31-year-old healthy man who refuses to work. Period. None of that changes the fact that my client has no ability to pay alimony. None of that matters to your decision. So why do they spend so much time on it? Because they have nothing else. They have no evidence, they have no case, they have no argument. They have tried to distract you all, confuse you, and make you think about anything other than the truth in this case. So the opposing party wants to be considered a house husband. That's what he called himself. That's the label he wants you to believe. Really, he's a passive moocher. That's what I would call it. You saw the photos. You saw the photos inside the home. The filth. It was filthy. It was messy. It was a biohazard. The opposing party claimed he did chores. Not a chore was done up in there. Okay. So much so that my client had to spend $1,600 for professional cleaning so that they would pass a fire inspection. He's talking about some. He took care of the home. He did not take care of the home. That doesn't even make any sense. And what was the respondent, Mr. Terry's, evidence to that? What did he introduce? What did he show you to prove his case? A picture of him and Soso, the dog. And a lot of text messages where my client was telling him in all caps, please stop spending my money. Where's the rest of his evidence? We've been here for 3 days and we don't have any other evidence. It's mind-boggling. The respondent wants to be taken care of for the rest of his life. That's it. That is what this trial is about, nothing else. He wants you, the jury, to grant that wish for him. Let's not do that today. He was incarcerated for 8 months for what he has done to my client. That's 8 full months. That's like a January to an August. It's August now, so just all year he basically would have been incarcerated. And now he wants money from my client to get back on his feet. His words exactly, I put it in quotation in my notes. He wants to get back on his feet, but here's the thing, he was never on his feet, ever. So the evidence showed that before living with David, he was living with father and his nana back and forth. He was not self-sufficient then. He's never been self-sufficient. And when I asked him yesterday, right here in this courtroom, I said, what were your plans when you plan to, he claimed he was planning to leave my client and, go do something else with his life, move on. I said, what was your plan to take care of yourself? He said he was going to rely on someone else. He said he was planning to move back in with his father in Arkansas. So he was never planning to get a job. He was never planning to be self-sufficient. This has never been his life plan. Grown man, mind you. 31-year-old grown man, mind you. So I also think that this is further shown by his family history. So he stated his nana was a stay-at-home wife. And his mother, before having him, worked in insurance. But once he was born, she transitioned into a wife and homemaker role. This is his words exactly. This is what he wants his life to be. He wants his life to mirror his nana and his mother at the expense of my client, okay? He wants to be a stay-at-home spouse or a stay-at-home divorce spouse. I don't know. Well, all of us gotta work. All of us are here dealing with this because he wants to stay at home. He wants David to work. He wants David to provide. He wants David to pay for everything. He wants a free ride, but that is not how marriage works. That is not how adulthood works. That's not how life works. This is the same man who said on the stand that one 45-minute Uber Eats trip exhausted him. His words verbatim, I'll do a long Uber Eats trip and then be like, woo, I'm tired. He literally said that. Well, we've been in here for eight hours times 3. He said that. This man just don't want to work. So he is perfectly capable of working. He can drive, he can read, he can write, he can work a computer, he has a GED, he has experience as a personal assistant, let him tell it. There's absolutely nothing stopping him from getting a job. His resume, the one he entered into evidence, he entered one more thing into evidence. It was a resume from 2014. Hope y'all remember that. His resume, the one he entered into evidence, conveniently showed that he stopped any type of work right before marrying my client. It showed he worked before the marriage and then nothing. David said that the marriage was an arrangement to ensure that Mr. Terry had health insurance, very scam likely, okay? It was a scam. The respondent, Mr. Terry, married David for benefits, for the health insurance, for the financial support, for the free ride, and now that the ride is over, he's trying to get more, okay? So let's talk about the law briefly. In Georgia, for alimony, you must show that one party has the financial need and that the other party has the ability to pay, okay? So it's a two-pronged test. We saw all those zeros on those financial and on that financial affidavit he submitted. I've never seen that many zeros in my life, honestly. So sure, he has a financial need, sure. But my client does not have the ability to pay any money to Mr. Terry. So I want you to remember my client's financial affidavit that was entered into evidence. I want you to look at the numbers. Numbers rarely lie. He makes $10,312 per month before tax, okay? And he may or may not get bonuses depending on if his boss likes him or not, whatever that means. So his net monthly income is $8,564 per month. His expenses are $7,200 per month minimum, okay? So he's bringing in $8,500, his expenses are $7,200. That's leaving him about $800 to spare just for other expenses. So that does not include, well, let me tell you what his expenses that I calculated, what it actually does include. His monthly payment to creditors. So let me list all the creditors. Kohl's, Discovery Bank, or is it Discover Bank? I don't know. I don't bank with them. Truist, Ally Bank, a debt consolidation firm, so paying an attorney to try to get rid of some debt. Mission Lane and American Express. So the outstanding balance, so not even including like the monthly fee adds up to $7,000, but the outstanding balance for all those creditors is $42,638.26. So once he gets done paying all that per month, then we can look at how much it costs for his living expenses. So it does not include, that 7,000 figure does not include his rent. It does not include his vehicle payment for Prius. It does not include food. It does not include insurance. It does not include utility, whatever else you might come to on a day-to-day type thing. His current checking account balance with Discover Bank is negative $203.67. He's in the red. His checking account balance with Truist Bank has a current balance of 12 cents. 12 cents. I didn't even know that you could keep an account open with 12 cents. His checking account with Bank of America has a current balance of 2 cents. Where does the opposing party, Mr. Terry, expect him to get $2,500 per month to pay him for the next 3 years? Mr. Terry needs to get a job. And then the opposing party has the nerve to say that my client is hiding assets. Please tell me, if this man looks like he is hiding assets, everyone look at him. Does he look like he is hiding assets and purchasing Louis Vuitton? Please tell me. That's not even believable, like, at face value. There was absolutely no evidence. Mr. Terry said my client was buying Louis Vuitton. I would really like to see that. There was absolutely no evidence introduced from the opposing side showing that there's hidden money. No bank statements, no receipts showing luxury purchases, no financial documents showing money disappearing, nothing like that. So we're just in here playing a guessing game at his whim. Got it. So this has been a waste of time, honestly. Sorry to y'all. So let's consider the law again, briefly. Under code section, the code section that addresses alimony is 19-6-1. It covers alimony and it gives the judges a wide discretion to reduce alimony by weighing the conduct of the parties, if you will. So the only specific marital misconduct that acts as an absolute statutory bar for getting alimony is adultery and desertion. Okay? And guess what? The opposing party committed adultery. So David testified that Terry would go hook up with men on Grindr throughout their entire marriage. And Mr. Terry never said that he didn't do that when he got on the stand all day yesterday. So that's adultery. That's a statutory bar to receiving alimony anyway under Georgia law. So he'd be prevented from getting alimony because he was hooking up with men on Grindr. So even if you set aside the abuse, you shouldn't have set aside the abuse. But even if you do set aside the abuse, the opposing party committed adultery. He cheated on David. He went out and found other men, and now he wants David to pay him under the law. He's not even entitled to alimony just by doing that. So, all right, finally, the dog. So, whatever. The dog that Mr. Terry wants you to give him. This is the same dog that's been in my client's possession solely since August of last year because the opposing party was arrested. He was in jail for 8 months, and now he's on house arrest in Statesboro. The dog has been with my client solely since August of 2025. My client has been feeding the dog, providing for the dog, ensuring that the dog is healthy, ensuring that the dog goes to the veterinarian. It's all up to date. And my client can actually pay to get those things done. David testified that the opposing party threw the dog He threw a defenseless animal. He threatened to snap the dog's neck. That's what Mr. Terry did. He refused to feed the dog, saying God will provide for the dog, so he no longer needed to feed him. He didn't even have the money to take the dog to the vet. He can't feed himself, let alone feed the dog. He can't walk the dog. He's on house arrest. Why would y'all award him the dog? I'm not quite certain. This ties into his God complex, I think. The same reason he requested to have you, the jury, here for 3 days. 3 days that you could have been with your families or at work, something that he refuses to do. Because he thinks you all are going to award him a meal ticket and feel sorry for him. Let's not do that. My client is a good man. He's a hardworking man. He's a victim of abuse. You can tell that even just by the pending criminal charges, okay? He has been through hell. He's been strangled, slapped, sprayed with chemicals, manipulated, financially drained, emotionally destroyed, and now he's being taken to court for money in a 3-day trial. He stands before you asking for you to do the right thing. Just do the right thing. He's asking for a fresh start. All he wants y'all to do is grant the divorce, let him keep his stuff, and let him go on about his merry way. The opposing party, on the other hand, 31 years old, grown man. He is healthy. He's capable of working. He has no children. He has no disability. He has no excuse. He needs to support himself. Do not give him alimony. Do not give him the dog. He can't even take care of the dog. Do not give him David's car, please. And do not give him David's money. And also make him pick up his stuff from storage this month, please. He's taken enough from David, and he's honestly taken enough from y'all, to be honest. So with that, I believe the deliberation should be very short, please.
Thank you, Ms. Yarber. So I need to give you the law now. Anyone need a break before we do that? It's okay if you want one. Mine is much less interesting than what they just shared with you. You good? Okay, just a little stretching. A couple of prefatory comments. Oh, and Mr. Polanco, if you don't mind coming up here to grab a final, this is the final version of the jury charge. 2 copies, one for you, one for Ms. Yarber. Thank you, sir. Appreciate it. I am going to be reading to you from this. This is the official jury charge. This is the law that you must apply to the facts as you find them to be. Feel free to take notes. I try to make this as accessible as possible, but there are some times where I'm required by higher court opinions to describe a legal concept in a particular way. So if it sometimes seems that's kind of wordy, my apologies, but you'll have this document with you. So if you're taking notes like, wait, how did he just describe that? You'll be able to consult this during your deliberations. Second, what I'm reading will be on the screens if everything is working. Some folks follow along better if they can see the words. So I'll be sharing this with you as your official legal instructions. It'll be up on the screen as well, and you'll have a hard copy for your deliberations. So let's get started. There we go. Is it on the screen? Both. Is the other one working, Deputy Gordon? I can't see. No? Are we good with just that one, or do you? Well, I'm glad you decided. Okay. Hopefully you all can see that screen, but again, you'll have this document. Oh, ever? Did you try making? Oh, you think because it runs through Ms. Okay, don't sweat it. It does run through. We'll have to come up with a fix for that at another day. All right, ladies and gentlemen, let's get that working. You have been considering the case of David Piner versus Christopher Terry. Petitioner, Mr. Piner, filed a petition for divorce, and the respondent, Mr. Terry, answered and brought a counterclaim for divorce. Though they assert different grounds for the divorce is agreed to by the parties and will be granted by the court, by me, upon the conclusion of the trial. You will be deciding issues incidental to the divorce. Each party is seeking an equitable division of marital property, and respondent, Mr. Terry, is seeking alimony. That's what you'll be sorting out. How do we divide things up that are part of marital property? And is Mr. Terry entitled to alimony, and if so, how much? Each party in this case has the burden of proof as to what he seeks. The party who has the burden of proof must prove his claim by what we call a preponderance of the evidence. Preponderance of the evidence simply means evidence enough to persuade you that the party's claim is more likely true than not true. In deciding whether any claim has been proven by a preponderance of the evidence, you may consider the testimony of all the witnesses, regardless of who may have called them, and all of the exhibits received into evidence, regardless of who may have produced them. If the evidence fails to establish any essential part of a party's claim by a preponderance, you must find for the other party as to that claim. Evidence is how facts are established or disproved. Evidence includes all the witness testimony and all the exhibits that were admitted. It does not include opening statements or closing arguments, any questions that were asked, or anything the attorneys or I have said. Of course, during trial, you were permitted to submit questions. Here they all are. The answers to those questions are evidence. You should draw no conclusions or inferences from the fact that some of your questions may not have been asked. Questions are not evidence, only answers are. And in considering all the evidence you've received, you should feel free to use reasoning and common sense to make deductions and reach conclusions. Evidence may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, like an eyewitness. I saw the car run the red light and hit the guy on the bicycle. I saw it happen. Circumstantial evidence is proof of one or more facts that tend to prove some other fact by inference. I heard screeching tires and it sounded like metal on metal. That could be circumstantial evidence that a car hit a bike, but you didn't see it. You experienced some things that suggest that other outcome. There is no legal difference in the weight you may give to either direct or circumstantial evidence, and you should not be concerned about whether the evidence you received was direct or circumstantial. You must determine the credibility or believability of the two witnesses you heard from. In doing this, you may consider all the facts of the case, the witness's manner of testifying, the probability of their testimony, and their interest or lack of interest in the outcome of this case. In deciding credibility, you may also consider evidence offered to attack a witness's credibility. This can include evidence of some prior inconsistent statement. Hey, before you said something different. And or that witness's bias for or against one of the parties in this lawsuit. Credibility may also be attacked by disproving facts to which a witness testified. Mr. Piner is seeking a divorce upon the ground that the marriage is irretrievably broken, which is a legal ground for divorce in Georgia. Mr. Terry is seeking a divorce upon the legal grounds of cruel treatment. A marriage is irretrievably broken if either or both parties are unable or refuse to cohabit, that means live together, and there are no prospects for a reconciliation between them. It is not necessary to show that either party is at fault in any way. The only question to be determined is whether there are prospects for reconciliation. Cruel treatment is the willful infliction of pain, bodily or mental, that reasonably justifies fear of danger to life, limb, or health. Mental anguish and wounded feelings, constantly aggravated by repeated insults, are as bad as actual bruises and can support a finding of cruel treatment. Equitable division. In this case, both parties are asking for an equitable division of property. The purpose behind this doctrine is to be sure that the property accumulated during the marriage is fairly distributed between the parties. In making an equitable division of property, you first classify the property as either non-marital or marital. Non-marital property is property that was acquired before the marriage or property that was acquired during the marriage by gift from a third party, not one of the spouses, or by inheritance. Non-marital property can be converted to marital property by an action of the property owning spouse. Whether non-marital property has been converted is a question for you to decide. Now, marital property is all the other property that was acquired during the marriage and that was not purchased from the sale or exchange of some separate property that was not property. So all that other property acquired during the marriage, that is marital property and is subject to equitable division. The fact that property is titled in the name of only one party or in the name of both parties is not the determining factor. Further, gifts of property between spouses during marriage does not exclude that property from equitable division. While property may initially be obtained as separate property, that property may be converted into a marital asset by the actions of the separate property owning spouse, such as transferring ownership to his spouse. As you're thinking about equitable division, think of the following. First of all, equitable division of marital property is not necessarily an equal division of the property. To make an equitable division of marital property, you should consider the duration of the marriage, any prior marriage of either party, the age, health, and occupation, and vocational skills and employability of each party, and the contribution or services of each spouse to the family unit. You should also consider the amount and sources of income, the estate, debts, liabilities, and needs of the party, as well as debts against the property and the opportunity of each party for future acquisition of assets by employment or otherwise. And finally, the conduct of the parties, both during the marriage and with reference to the grounds for divorce, is relevant, and you may consider that in determining what is an equitable division of marital property. The law permits you to make an equitable division of marital property in several ways. First, you may make an equitable division of specific personal property or real property. That is, you may designate a specific property, such as shares of stock or a certain house or tract of land or a pot or a pan, to be awarded as equitable division of property. You may make an equitable division of property in cash. That is, you may designate a certain sum of money to be awarded as an equitable division of property, even though that sum of money is not presently in the form of cash. Third, you may make an equitable division of property by awarding specific items and also awarding cash. And finally, you may award percentages of property to spouses or require the parties to sell the property and award the proceeds equitably to the parties. Sell X to get the cash, divide the cash in the following way. Alimony, our other topic. The respondent, Mr. Terry, is asking for an award of alimony. Alimony is defined as an award from one party for the support of the other when the parties are living separate and apart. You can fashion an alimony award from anything that a person owns or is awarded to them as their equitable division of property or from future earnings. You are authorized, but not required, to award alimony to the party claiming a right to alimony in accordance with that party's needs and the other party's ability to pay. If you decide to award alimony, you should take into consideration whether this award is in place of or in addition to an award of equitable division of property. Additionally, you should bear in mind that assets assigned as non-marital property that were not subject to equitable division may be awarded as alimony. Before considering the amount of alimony to be awarded, you must first decide whether the party requesting that alimony should receive any at all. A spouse is not entitled to alimony as a matter of right solely because the parties were married. In determining whether to grant alimony, you should consider evidence of the factual cause of the separation between the parties. You may also consider evidence of the parties' conduct toward each other, how they treated each other. Amount of alimony. If you determine from all of the evidence that the party claiming alimony is entitled to it, you then have to decide the amount, type, or kind of alimony to be awarded. And in deciding this, you should consider the following. 1, the standard of living established during the marriage. 2, the duration of the marriage. 3, the age and physical and emotional condition of each party. 4, the financial resources of each party. 5, if applicable, the time needed for either party to acquire sufficient education or training to enable him to find appropriate employment. 6, the contribution of each party to the marriage, including services rendered in homemaking and career building of the other party. 7, the financial condition of each party, including their separate estate, earning capacity, and fixed liabilities. And finally, any other relevant factors that you think are equitable and proper. If you decide to make an award of alimony, you should bear in mind that the law permits you to award it in several ways, including, I'm going to talk to you about 2. The first is lump sum alimony. Here's what you get, one amount, that's it. You may make a lump sum cash award to be paid out of the estate or assets of the other spouse. And you may require that that lump sum be paid in one payment or installments for a specific period. If you find that the evidence warrants the payment of a lump sum of alimony in installments, you should bear in mind that this award is considered a property award and it will not terminate upon the death of either party, and that these payments will be payable to or by the estate of a deceased party. The other form we were talking about is periodic alimony. You may make an award of periodic alimony payments to be paid in the future, for instance, weekly, monthly, or quarterly. This award of periodic alimony payments will terminate upon the death of either party, and it is not chargeable to the estate of a deceased party. Also, obligations for periodic alimony end upon the remarriage of the party to whom the alimony is being paid or the obligations are owed, unless you specify otherwise. You may make an award of alimony by using one or a combination of these methods. I know it says 3, but the parties and I agree the third method is not before you. Any award you make for alimony should take into consideration whether this award is in place of or in addition to an award of equitable division. We're almost done. Non-marital or separate property. Non-marital property that belongs to one of the parties may be taken into account in deciding questions of alimony. One of the first jobs you have when you go back to deliberate is to select a foreperson who will preside over your deliberations and who will sign the verdict form to which all of you freely and voluntarily agree. You should start your deliberations with an open mind, consult with one another, and consider each other's views. You must decide this case for yourself, but you should do so only after a discussion with your colleagues. This is the verdict form. I'm holding it in my hands now. You'll have it, obviously, during your deliberations. It is a little more complicated than if you've been in a criminal case where it simply lists a count. You say guilty, not guilty. You'll be filling it out in some detail, depending on what you decide about dividing things up. And I'm going to talk to you a little bit about what the form of the verdict will be. As you are deciding the determination of non-marital property, your verdict should state specifically which property is non-marital property of each party. The car is non-marital property of this person. The fork is non-marital property of that person. As to the equitable division of property, your verdict should also state specifically what property and what interest in that property you are awarding and to whom. This person gets sozo. This person gets the couch. When it comes to alimony, your verdict should first state whether you find Mr. Terry is entitled to alimony. If you find that he is not, you're done with the alimony section. If you find that he is, you need to set forth what type of alimony, lump sum or periodic, and how you are awarding it. If you find for a lump sum award, your verdict should set out the amount and the date of the payment. If you find that it is to be paid in installments, you should set out the dates or times when installments are to be made and the amount of each installment. If instead you find for periodic payments of alimony, your verdict should set forth the amount you are awarding and then designate how frequently, weekly, monthly, or whatever other period you decide, and for however long you think that payment should go. It should go for 1 year. It should stop after 18 months. If you find that any obligation for periodic alimony should be terminated at any particular time in the future, remarriage, death, solar eclipse, or suspended for any period in the future, or terminated, or continued upon any particular event, you should set that out in the verdict. You're setting the ground rules for how alimony will be paid. You may also provide for changes in the amount of alimony to be paid in the future. You should specify the changed amount and the particular time or date or event that will cause that change to take effect. If you are employed, alimony is reduced. If you're not employed, alimony is increased. These are all factors you can choose to include. Whatever your verdict is, ladies and gentlemen, it must be unanimous, meaning all of you agree to it. It must be in writing, that's the verdict form, and dated and signed by your foreperson. There's a place at the end for the foreperson to sign and date it. Your verdict should be based upon your opinions of the evidence according to the laws that I'm about done giving you. You must consider the facts objectively, without favor, affection, or sympathy to either party. By no ruling or comment that I've made have I intended to express any opinion about the credibility of witnesses, the evidence, or which party should prevail. My only interest in the matter is that the case be fairly presented according to the law, and that you, as honest, conscientious, impartial jurors, consider the case as you've been instructed and return a verdict that speaks the truth. You've heard this before. During your deliberations, you must not communicate with anyone outside your group, nor may you conduct any outside research. You have all of the evidence that you're going to get in this case, and it would be improper to supplement it. To make that easier and more certain, Deputy Gordon will be collecting all of your electronic devices. So while you are deliberating, no phones, no Apple Watches, Google Glasses, or anything that could connect you to the outside world. You'll get them back, I promise. They're just going to be in my chambers. But while you are discussing the case, it's you, the evidence, the whiteboard in there, the verdict form, that kind of thing. And no, I'm bored, I'm going to play something on my phone, or I'm going to look something up on my phone. Finally, during your deliberation, should you need to communicate with me for any reason, you've got a question, a concern, that has to be in writing. So put it down on one of the pages from your notepad or grab some of those note cards. You'll get it to Deputy Gordon. I'll take that question or concern, share it with the lawyers, and then respond in whatever way I'm allowed by the law to give. And that allowed by the law is an important one, because you may have a great question to which I know the answer, but I can't tell you, because it's the kind of thing that you have to figure out on your own. So don't be annoyed if sometimes my answers are, if you have questions, you need to sort that out yourself. It's not because we couldn't figure out an answer, it's because legally we don't weigh in on that. That's a jury issue and not a judge can help with issue. I don't say that to discourage you from asking questions. Ask them if you've got them. You'll be able to sort out after a while, like, oh, he's not going to tell us what the witness testimony was. We have to remember that from our notes and our independent recollection. Ladies and gentlemen, that concludes my instructions to you. So I need everyone except for Mr. Goodwin and Mr. Jones to go in the jury room. Please don't start your deliberations until you get the jury charge, the verdict form, and the exhibits. That's going to be about 4 minutes. The exhibits are ready to go. We just need to get that together, get it to you, and Deputy Gordon needs to take your electronics. I'm going to talk to Mr. Goodwin and Mr. Jones in just a second. But for the rest of you, it's time to head to the jury room. Thank you.
All right, the jury. You stay with that.
Gentlemen, you are alternate jurors. We didn't tell you that in advance, so you wouldn't zone out. You are our contingency plan if we had lost a juror in the middle of the trial, and these things happen, someone's family member gets sick and juror 7 is suddenly gone. Well, we're okay because we then have 13 jurors. And if we lose 2, we then have 12 jurors. And we still may lose someone. If the deliberations are not completed today, one juror has already said, I'm out of here. And so one of you then would become a deliberating juror. They'd have to start over. You don't come in part way and they say, oh, we've already figured everything out. Actually, they would restart deliberations. I'm going to ask you all to stay today. If they don't finish today, we can talk about whether you can go about your business, but if you can be here within a certain number of minutes, you just need to respond to a 911 call from us saying, actually, we need you, come on down and please join the jury. But for today, I'm going to have you stay. There's a jury room through that door that has a little tornado on it, and that's where the 2 of you will be. You can keep your electronic devices. Just don't use them to research about the case, and don't do your own mini deliberations. Hey, what would you have done? Because it could be intermittent. One of you is pressed into service because something happens and I have to excuse a juror. So you continue to be essential components of the process. You need to stay in your information bubble. You can do work, you can do whatever on your devices, zone out, whatever. We will not forget about you. If they reach a verdict, we'll come in, take that verdict, and assuming the verdict is structurally correct, we'll then bring you in, and when I dismiss them, I'll dismiss you guys as well. If they reach 5 o'clock and they want to go home for the day, but they're not done, again, I'll make sure to bring you out and we'll sort out, could you guys be here on short notice or do you need to show up when they show up tomorrow morning? Okay. Any questions about that process?
No.
Nope. Okay.
My phone.
You're going to go grab your stuff. I just needed to tell you, you're going to keep your pads.
Okay.
Keep your pads, get your electronic stuff. Deputy Gordon will get you into jury room number 2. There are restrooms in there, so you should be self-sufficient. If you need a break or something, get his attention so he can let me know, hey, Jones went this way, Goodwin went that way. Okay? Thank you. Any exceptions to the charge, Ms. Yarber? Mr. Polanco? Okay. If you all want to be, not quite yet, but in a moment, at ease and not necessarily glued to your seats here, if I can get a cell phone number for the 2 lawyers, we'll call you. You're responsible for your clients. We're making 2 phone calls, not 4, to get everyone back in here. You're welcome to stay here. I don't have any more court this afternoon, but if you want to circulate in the building, I just need that phone number, and you can put it on one of those note cards. Deputy Gordon, I'm going to hand you this. That goes with the exhibits that you'll get from the 2 lawyers, and that should be everything.
Okay.
Drop the laptop in your head. Yeah, just some work done.
Yes.
All right, so I'll put everything on hold in here. Are you just going to stick around? Is that the plan? Okay. The 2 clients can go wherever. I need the lawyers here, and lawyers will keep track of you all.
Thank you, sir.
And I'll be out of here in just a second.
An hour and 45 minutes later.
I'm not sure if it would have to be claimed as, in this case, the petition, the original petition. And that's what you're going after, or if it's sort of collateral to say irretrievably broken. Does that make sense?
I follow you.
I'm not sure about that part, but
Okay.
otherwise I'll defer.
Okay, the relevant statute is 1961. Subsection B says, a party shall not be entitled to alimony if it is established by a preponderance of the evidence that the separation between the parties was caused by that party's adultery or desertion. So I don't think it needs to be pled. I think because that law is there, it probably ought to have been flagged as a pattern. I'm not faulting anyone. I'm new to this space, but I'll keep that in mind in the future. But two, it is a correct statement of law that applies in this space. And that's not me finding that anyone has proved anything by a preponderance. That's part of it, is that there's a burden. But the question's now out there, and I think the jurors are entitled to a proper legal instruction. This isn't the question, we don't have enough evidence, or what is the evidence on, or something like that, that I need to leave to them. It's a question about the law, and that void is my role to fill. They fill the evidentiary voids or questions that they've got. So I hear your point. I don't think a failure to plead it, and it really would have been, I guess, a response to the counterclaim, and a party's not required to respond to counterclaims, would have been, we think that alimony is not appropriate because of alleged adultery. So I think it's an open question that merits an answer, and let me print something out, let you guys read it, and then we'll get it to the jurors.
Is that the only question, Judge?
Yes, ma'am.
Okay.
You shot me. Hold on. You hit me. That's kind of how it works. I understand that. Yeah. Let's take a look at what's on the screen, and this is the pattern charge. The only thing I changed was it had a he and she, or he or she, or his or hers, and I got the genders linked to where we are. But this is the pattern charge for this application of that statute that I mentioned. Ms. Yarber, are you all right with this language?
Yes, Judge.
Mr. Polanco?
Yes.
Okay. Let me get it printed, and we'll get it to the jury. And Deputy Gordon, if you would, when you're back there, ask them how late they want to stay. And if they need to discuss that with us, then we can bring them out. And we'll take it from there. Hopefully the printer makes a happy noise. If you ever need to print something out in order to save yourself from an approaching horde of zombies, this is the wrong printer to use. It takes forever. Go. That's the language. Here's their question. Together. And there you go.
Yeah.
Thank you, sir. And we're going to sit right here. You can let us know what they say about timing. We'll wait right here before we break again.
I have a side note question, Judge. With the live streaming, is some stuff that happens in here supposed to be loud and some stuff muted? The reason I ask you that is because I've been watching it and I see that we're still live on YouTube, but you're muted. So can the public not hear the jury question?
So I muted it when we took a break, so you all could speak freely and it wouldn't be broadcast. I forgot to unmute it when I came back.
Could have been able to hear it.
They 100% could have, and I got a notice, and so that's probably a little bit delayed because I unmuted about 4 minutes ago.
Oh.
So the first part of the discussion about what the juror question was and probably the exchange I had with Mr. Polanco about, well, but what about if it wasn't pled? Unbeknownst to me, we were still muted. I don't have a light that shows that. It's a different screen. But I always try to remember to mute when we're taking a break so you can speak freely in here and not worry about like, hey, that judge is an idiot. And like, whoa, what? It just went out there. So I will.
Serious, Judge. Thank
Yeah.
you for telling me.
You bet.
Minutes.
They think they'll be done in 5 minutes,
Yes.
so we should sit tight. Okay, I'm gonna still go back to chambers because 5 minutes for a jury could be different in human time, but folks should stay nearby, please. We have a verdict. So I will bring the jury out in a minute. Ms. Yarber, is there anything we need to cover before I bring the jury out and receive the verdict?
No, Judge.
Mr. Polanco?
No, sir.
Okay, Mr. Piner and Mr. Terry, I don't know if you've ever had a jury trial before, but it is important that while the verdict is being published, the foreperson will actually read the verdict aloud, that you all remain stoic. It may not be what you wanted to hear, it may be exactly what you wanted to hear, but no outbursts, I can't believe that, anything like that. I don't say that because I expect anything like that from either of you. This is just a different situation. And so I provide that cautionary instruction. You'll have time of planning to talk with your lawyer about what does this mean? Why do you think this happened, et cetera. Okay? Let's bring the jury in, please.
All right, the jury. Judge President of the County Court. I got the alternates.
You got the outs. I was gonna say, we shouldn't have 14. You can take a seat, except for you, Mr. Lynn. You guys stay standing. Alternates, you did not participate in deliberations, correct?
That is correct.
You were brought in after the verdict was reached.
Yes.
Okay, all right.
We got nothing else.
No, good. I know that's where you started. I just was surprised that there were 14 people, but as long as Deputy Gordon got you after the rest of the jury was done, that's not an issue. Mr. Lynn, you're the foreperson?
Yes, Your Honor.
All right, and the jury's reached a verdict?
Your Honor, we have.
Did you complete the verdict form?
We did.
Okay, if you give it to Deputy Gordon, take a quick look at it. All right, Gordon, I'm going to ask you, sir, to publish the verdict, which means starting not at the very top where it says Fulton County, but section 1, divorce. If you'll just read in to the record what you and your colleagues decided.
Sure. So part 1 for divorce, both parties have petitioned for divorce. And we, the jury, find the divorce is based on the following ground, which is irretrievably broken. Determination of separate property. We, the jury, find as follows. A little confusing for this part. I think we made a mistake. This goes on marital property for the two.
Okay, why don't you hand me the verdict again?
This is why I wrote it on the second page instead.
Okay. So why don't you read it all on the record? I'll talk with the lawyers and we'll see how we handle that. It's not inconsistent, but you did put it in two places.
Got it. Okay, so we, the jury, find the following. Petitioner Piner's separate property is, the Prius goes to Piner. Respondent Terry's separate property is Sozo, goes to Mr. Terry. Everything in storage is to be retrieved by the end of August in the year 2026. In equitable division of marital property, Petitioner Piner is awarded the Prius. Respondent Terry is awarded Sozo the dog. Petitioner Piner shall assume and pay for all his own debts. Respondent Terry shall assume and pay for all of his own debts as well. In the matter of alimony, we find Respondent Terry not entitled to alimony.
There was one section about property in the storage facility. Did you indicate in your verdict form who it was who was supposed to collect that property and to whom it would belong? Or you said?
Yes, so Your Honor, it belongs to Mr. Terry and everything in the storage needs to be retrieved by the end of August 2026.
Okay, so it's Mr. Terry who needs to get that and get it out of there by the end of this month.
Correct.
Understood. Thank you. Deputy Gordon, if you would, and you signed and dated the jury, the verdict form? All right, if you get that to Ms. Yarber, please. Ms. Yarber, do you have any concerns about the form of the verdict?
Judge, one concern, I guess, under the alimony section, there are multiple no's that could be selected. It is inferred from the first one, when they asked if Respondent Terry is entitled to alimony, that the no would cover the rest of them.
In fact,
I
the
believe
instruction immediately following that is if you
Okay.
circle no on the first one, you're to skip
Skip
the remainder, which they did. If your answer is no, you are done.
Okay,
Sign and date the verdict. And they circled no. And then if you keep going, the next thing is the dated and signed verdict.
perfect.
Okay,
Thank you, Judge.
you're welcome. Mr. Polanco, any concerns about the form of the verdict?
No, but I'm just referring to what Mr. Foreperson, Mr. Lynn said, that something was mentioned twice. I didn't see it really listed twice,
Well,
but I don't know.
they put the Prius as both Mr. Piner's separate out of marital estate property, as well as something as a result of the equitable division of the marital estate, the Prius went to Mr. Piner. And then the same with Sozo. They put Sozo on the verdict form, that's separate property, not part of the estate, but also said it is part of the estate. Sozo is part of the estate, but it goes to Mr. Terry. Because the distributions are the same or the allocations are the same, I view this as a non-material defect. I don't think we need to send the jury back. If they had said, Mr. Piner gets Sozo, not part of the property, the marital estate, and then Mr. Terry gets Sozo, part of the marital, hey, wait a minute.
Yeah,
Sozo can go to one place.
the result is the same. It's not inconsistent, right?
I agree. With that explanation, you're accepting the form of the verdict.
Oh, no. Other than, no.
You're not accepting the form of it. So what is your legal objection?
No, I'm not objecting.
Oh, okay, good. Okay, excellent. Anything else, Ms. Yarber, before I release the jury?
No, Judge.
Mr. Polanco?
No, sir.
All right, ladies and gentlemen, on behalf of Mr. Piner and his attorney, Mr. Terry and his attorney, I want to thank you for the 3 days that you've given us. I'm going to ask you to retire to the jury room. I'm going to be back there in just a minute to thank you a little more thoroughly, answer any questions you may have, and then you'll be on your way. But I hope you know that you brought closure to a situation that Mr. Piner and Mr. Terry weren't able to achieve without your involvement. It's like I told you, Tuesday morning, you're here for an important purpose. And as you surveyed things, you may have thought, well, why couldn't this be sorted out? It wasn't. It wasn't sorted out, and we call upon the community to do it, and you've done that. And there's a punctuation mark at the end of this situation now. The case is closed. Mr. Piner's going to go his way. Mr. Terry's going to go his, and you've allowed that to happen. So thank you for your time. I'll see you in a second. Ms. Yarber, anything else on behalf of Mr. Piner?
No, Judge.
Mr. Polanco, anything else on behalf of Mr. Terry?
No, Your Honor, thank you.
I'll get the verdict filed, and we'll take it from there. If there was nothing else, then Mr. Piner, you and Ms. Yarber should go first. And when Deputy Gordon gives you, Mr. Terry, the green light, you and Mr. Polanco can go. And I wish you both the best going forward. I hope there are some positive memories from your time together. That chapter has closed. You should know, Mr. Terry, that whatever is still in place as conditions of bond, totally unchanged by these results. So if there are things you're supposed to not do because Judge Leffridge or another judge put it in that bond order, that's still the case. This dealt with your marital situation and the property that was connected with that. It doesn't have anything to do with the stalking case. You've still got a great lawyer plugged in with that. Keep him posted, follow his advice, but don't assume that anything's changed on that front because of this, okay? All right?
Sorry, just may I ask, so I was thinking this morning, logistically, can we get help from sheriff's office, or how do these things actually get executed?
It's a great question, and I'd ask you to talk with Ms. Yarber, not now, because it's 5:30, and it's been a long week, but reach out to Ms. Yarber or Mr. Castellan. If you hit a dead end with them, I'm happy to get in the mix and say, come on, people. But we need to sort out how Mr. Terry gets Sozo and how Mr. Terry gets access to the storage unit. Based on this order, this verdict, those are the only two touch points. And so we can sort out if there's a third party where Sozo would be delivered to mutual friend X, not for safekeeping, but I'm making this up. You drop him off at 10, and at 10:15, Mr. Terry shows up and he has Sozo. The lawyers need to sort that out so that Mr. Terry isn't inadvertently in your space. You can agree, look, this is the way we're going to do it, Mr. Piner, where actually Mr. Terry is briefly in your space, but you're not required to compromise that safe zone that's been created to achieve these two ends, which is get Mr. Terry into that storage unit, not at midnight on just one night, but accesses a lot of stuff he needs to get out of there.
His name's on it, so. Yeah.
Pardon me?
His name is on it, but Your Honor, we will work it out among.
Good. The lawyers will work it
I'll make
out.
sure she has the keys.
Good.
And sign
We can
any
do it,
lock
Judge.
break thing.
Yeah.
We'll get it done.
Excellent.
Thank you, Judge.
You're welcome.
Judge.
Scoot.
Thank you very much. Thank you.
You're welcome.
Okay.
All right, so you sit tight until Deputy Gordon gives you the green light. He just needs to make sure that Mr. Piner is on his way, okay?
You got it. You've been a really good judge.
Hey, thanks.